Hello everyone, welcome to Legaldarshana. In today's video, we are going to discuss a very important topic of Indian Evidence Act, that is Estoppel or Law of Estoppel. There are some facts of which evidences cannot be given. It is the rule of evidence that a person alleging contrary facts will not be heard. This rule is supported by the legal maxim elegans contraria non est audendus. The principle of estoppel says that a man cannot approbate and reprobate, or a man shall not say one thing at one time and later on says a different thing. The law of estoppel in Evidence Act 1872 is contained in section 115. According to the said section, when a person by his declaration, act or omission intentionally causes another person to believe a thing to be true, and on the basis of that belief to do that thing will not be allowed to deny the truth of the thing represented. The provisions of estoppel are founded upon the well-known doctrine laid down in the leading case of Pickard versus Sears in 1837. In this case, the rule was stated as below: where one lay his words or conduct willfully causes another to believe for the existence of a certain state of things and induces him to act on that belief so as to alter his own previous position, the former is precluded from arriving against the latter a different state of things as existing at the first instance. It was also held in the case of Pickard versus Sears that the object of estoppel is to prevent fraud and secure justice between the parties by promotion of honesty and good faith. Below are the conditions for the application of doctrine of estoppel in section 115 of the Indian Evidence Act 1872. There must be a representation made by one person to another, and the other person to whom representation is made believes it to be true and acts upon it, thereby altering his position. Then, in the suit between the parties, the person who represented the fact or situation shall not be allowed to deny the truth of his representation. However, where there is a conflict of estoppel, that is, both the parties have represented some fact to the other party, they both are stopped from denying from both the facts, and therefore the estoppel cancels out each other's deed. Moving on to the nature of estoppel, estoppel is used as a rule of evidence. It is a matter of pleading and it acts as a substantive law. Estoppel is a rule of evidence. It is only a rule of evidence and has come similarly an irrefutable presumption of law. It is used to prevent the other party from rebuttal of the facts alleged by them. Estoppel is a matter of pleading. The party who relies on the said belief or facts represented by other parties must plead estoppel in order to enforce the representation made by another party. The estoppel is pleaded by parties, and court do not validate such existence of estoppel until and unless pleaded. Now, estoppel as a substantive law, estoppels generally do not find a cause of action, for they involve no claim. They all are taken to be as an irrefutable presumption, just as the substantive laws. Moving on to when estoppel can be pleaded. Estoppels can only be pleaded when they are certain, they do not circumvent with the existing laws or are not made contrary to the laws. They must be reciprocal and mutual, that is, accepted by the other party and stated by the first party, and the terms of estoppel must bind both the parties. In the case of Sanatan Gowda versus Behrampur University, the university was stopped from removing the appellant from the course after 2 years of his admission to the course. The court held that since at the time of admission the university did not object to the eligibility of candidate, it was then stopped to do so after 2 years from going contrary to it. It is also interesting to note that estoppel applies only against a fact and not against the law. It does not apply in the case of fraud or coercion or in the case of just tertai, that is, illegal possession of the property. Therefore, if there is a person A who intentionally and falsely leads to B to believe that certain property or land belongs to A and therefore induces A to buy the property and pay for it, the land afterwards will become the property of A and A is stopped from denying to this fact, and therefore A cannot seek to set aside the sale on the ground that at the time of sale A had no title. Estoppel will apply against A and the property or the land will be taken as the property of A by the eye of law. However, if the person buying the land already had the knowledge of the actual state of things and had an idea that the property does not belong to A, then the estoppel cannot be invoked. The person claiming the benefit must show that he was really not aware of the true states of things. This was all for today's video. I hope you would like it. For more such videos and for any feedback, query, or suggestions, please follow us here at YouTube. Please don't forget to like, share, subscribe, and comment down in the comment box below. Thank you. Have a nice day.